Right, back to our lead story now, which was, of course, the resumption of the Oscar Pistorius trial. He appeared briefly in the Pretoria Magistrates Court today. Of course, was postponed, but something that came out of it was an interesting comment by the magistrate, saying he is concerned that Oscar Pistorius will receive a trial by media. Just how much of a concern is that? Media law consultant Emma Sadlier is with us in studio this evening. Emma, thanks for coming in. Well, the judge clearly is worried about this, but does it actually matter in a judicial system where we don't have a jury making the final verdict?
It's such an important point you make, because I think that's really the big distinction between how we approach these matters in South Africa and how they're handled overseas. So in South Africa, we do have an offence of contempt of court. That is where the media oversteps the mark. Now, the test in South Africa, since the 2007 case of ETV versus the Director of Public Prosecutions, the test is a very, very high threshold. And the test that we have at the moment is there a real risk that substantial and demonstrable prejudice will occur to the administration of justice? Now, that's quite a difficult legal test to meet. It basically means that the judge could read what is being published or watch television, and it could influence him to the point that there is a real and substantial risk that he will change his mind about the outcome of the trial. So it's a very, very high level. And as you say, I mean, the jury system, you know, if you and I were on the jury, presumably we'd be far more influenced by what we read, whereas the judge has to be held to that higher standard of, you know, being a little bit more robust and really deciding on the evidence that is put before him in court.
And Emma, the crime scene photos that Sky News aired last week, we would presume form part of the material that should be sub judice under this case. Did they cross a line there?
I don't think that they crossed the line. I don't think that those photographs met the test. Now, just because I don't think that they meet the sort of the test for being unlawful, there are still, you know, questions of ethics and codes of conduct and that kind of thing. So I think that it's an ethical question, should those photographs have been published. I think that they didn't overstep the line. Had there been the body of Reeva Steenkamp, then I think perhaps that would be very, very close to pushing the boundaries. But, you know, as Pierre de Vos wrote in his article this morning, think of the Marikana shootings. You know, there we saw actual dead bodies. We saw the crime scene. It's not unusual to see photographs of crime scenes in these cases. So given the very sort of high-profile nature of this case, I think that we should expect to see the media publishing all the information they can really get their hands on, and provided it doesn't cross the line, i.e., you know, change the judge's mind, then it should be fine.
You know, it's interesting that the judge specifically speaks about a contempt of court charge. I mean, are local media then that reprinted or broadcast the crime scene photos, are they simply safe now that these...
Well, as you say, they have been in the public domain. I would imagine that the local media houses who have published the photographs have taken their own legal advice, because just because something is in the public domain doesn't make it fair game. So I would imagine that they did take legal advice. And as I say, I don't believe that those photographs the publication of those photographs was unlawful. And I don't think that they even cross over the ethical, the sort of the codes of conduct that journalists are required to adhere to in South Africa. So I don't think that we have crossed the line. I think that what came out of the magistrate today was really a warning. I think that it was really, and I think it was particularly directed at the international media. You know, this is the case in South Africa, and you need to adhere to the rules in South Africa. So I think it was really a warning, and I think that nobody has overstepped the mark yet, but, you know, given that it's such a high-profile case, it may well happen.
And it's interesting that we seem to be experiencing a number of precedents with regards to ethics and legality in this case, and it's hardly got underway, has it?
Absolutely. But, you know, in South Africa, the test is very, very difficult to meet. J. Arthur Brown recently in the Fidentia case, he sought to get a stay of the proceedings because he thought that there had been so much coverage of it, so much of it negative towards him. And the court said no. Yes, there had been effectively trial by media, and while that's not desirable for the parties involved in the case, provided it's not going to influence the judge's decision, and the judge is not a sort of wilting flower. You know, he should. We would hope that he will decide the case purely on the evidence put before him in the court. Then it's fine. So given that we don't have the jury system here, that we don't have lay people sort of reading the newspapers, watching the telly, then I think that it's fine.
What about the issue of defamation of character? I mean, we look at stories like the Johan Kortzer story, where he's often referred to as in newspapers as the Mode Mole monster. Now, should he come out smelling of roses at the end of that trial? I mean, what lines have been crossed?
Well, in the Oscar Pistorius case, we've got quite a distinct scenario here, because we've got a version from him in his affidavit, which was put before the court in the bail proceedings. So there is no question that he killed Reeva Steenkamp. Whether it meets all the elements of murder will be decided at the trial. So you cannot call him a murderer yet, because that has not yet been proved. You can call him a killer. So, you know, it's a very fine line, but it's unlikely that I would imagine that he would sue for defamation afterwards, because he would then have to take to the witness box to prove that, you know, that there was no truth or public interest in the allegations that have been published. So I think that it's unlikely that he will take steps, but that doesn't mean that he can't. So if he was to come out of it and the judge finds that, you know, the killing wasn't unlawful, or that he lacked intention, negating one of the elements to the murder, then he will be able to sue people who have called him a murderer for defamation, because obviously that is very defamatory. And then the trial in that case would probably reassess very much what has already been covered in the criminal trial.
Emma, on the one hand, we have the judge raising his concerns about this issue. On the other hand, we have Reeva Steenkamp's parents at around the same time doing an exclusive interview with an international television channel.
Yeah.
Is it double standards?
I think that the Steenkamp family is entitled to speak to the media if they so wish. They've so far only chosen to speak to the international media. They I think, ask questions. I haven't seen the documentary myself, but I believe that they ask questions. But there are no conclusions yet drawn by them. So I think that it's, and you know, bearing in mind the parents are viewers to the trial and will be reading reports and reading the newspapers and watching the television coverage. The journalists have to be sensitive to that kind of audience. But, you know, there are ethical obligations and there are legal obligations. And thus far, I haven't seen the media cross over that legal line.
Emma Sadlier, very good talking to you. Thanks very much for coming in.
News that moves. eNCA.com.